Support for WUWM podcasts comes from Potawatomi Casino Hotel Milwaukee, home to 24/7 excitement, dining, and an on-site hotel at 1721 West Canal Street. More information at potawatomi.com.
You're listening to Lake Effect Spotlight from WUWM, Milwaukee's NPR station. Here's one of our favorite conversations about the people, places, and organizations that shape Milwaukee.
Shorewood resident Paul Florsheim was ticketed for trespassing for walking along the Lake Michigan shoreline. Florsheim was walking north of the public Atwater Beach, where residential homes meet the shore. Florsheim took the case to court, arguing it's everyone's right under Wisconsin's public trust doctrine to walk along the lakeshore. But last week, a municipal judge found Florsheim guilty. He plans to appeal. Rob Lee is a staff attorney at Midwest Environmental Advocate. He says his team is following the case because it could go to the Court of Appeals or even the state Supreme Court. Lee joins WUWM's environmental reporter Susan Bence to talk about the ruling and the implications.
It appears to be a really well thought out and clearly written decision. And, regardless of the outcome here, I certainly understand how that outcome was reached. Just pleased with the judge taking the time to try to get it right to the best of their abilities. That's all we really could ask for, and that was knocked out of the park.
So what stood out in this ruling? You said it was long, and she definitely spent time on it.
The first thing we have to remember, right, is that this is a municipal court, and neither municipal courts or Wisconsin circuit courts get to make binding law. So yes, this is the outcome, and it was binding on Mr. Florsheim for right now, but he certainly has the chance to appeal that. But that's the first thing. When I was reading this is, what does this look like if and when it gets appealed? And so the factual findings, one thing that jumped out at me, or I would say two things in the factual findings, is the very clear finding by the judge that Mr. Florsheim did not go above the ordinary high water mark, and also finding very clearly that he was on the dry sand. And the reason our organization is even following it is because it has the chance to go up to a Court of Appeals or a Wisconsin Supreme Court and make a law, or at least clarify what the law already is. And so those factual findings are important because it does mean we're in that zone of exposed shore below the ordinary high water mark, but out of the water. And that's the real question, is when that does not have water there, can the public or Mr. Florsheim, right, access that narrow strip of land? Obviously, his position is he can, and the Village of Shorewood's position is that he cannot, right? Hence the dispute, hence the case. But those legal findings make the issue much clearer. It's not muddied up. If and when it's appealed, very clearly put this question about that strip of land, the exposed shore, in front of a court who, when they rule on it, will apply not to only Mr. Florsheim, but to anyone coming to Wisconsin and wanting to enjoy, at the very least, the Great Lakes.
Paul Florsheim has said he plans to appeal his case. Can you explain that process briefly?
Anytime a municipal court makes a decision in a certain type of cases, including Mr. Florsheim's, that the losing party has the option to appeal that decision to a Wisconsin circuit court. It's possible to request a whole new trial to maybe further develop the facts or do whatever it may be. Or it's possible to just have the circuit court act more like the Court of Appeals does and simply review the municipal court's decision. And that's, I think, a decision for Mr. Florsheim to make.
Wisconsin's fellow Lake Michigan neighbors, Indiana and Michigan, as you know, have sorted through this issue about the public's right to enjoy the Great Lake shoreline, right? Could those decisions influence what happens here ultimately in Wisconsin?
I really think so. And maybe getting back to one of your first questions about what struck me about this decision was the judge's decision effectively boils down to there's this 100 and now 3-year-old case out there that seems to be clearly on point from the Wisconsin Supreme Court. And as a municipal judge, I do not have the power to reverse that. However, in the decision, Judge Kirchner acknowledges the developments in the law over in Indiana and Michigan. And also, what I think is really interesting, she points out that Dammel, that's the name of the case, Dammel v. Jantz from 1923. That case was based in part on Michigan and Indiana case law preceding it that has since been overturned and clarified in the two cases from Indiana and Michigan, respectively. So if that underpinning from the case the court feels bound to is gone, then that may give a court of appeals or Wisconsin Supreme Court cause to revisit the decision issued again over 100 years ago.
Do you think this case, depending on how things unfold, do you think this is going to be watched closely? And if you think it's going to get a lot of attention, why?
Well, I think given those factual findings I talked about in this specific case, it certainly is a test case that can be applicable not to just all Wisconsinites, but anyone coming to Wisconsin, right, has a constitutional right, public right to engage in recognized uses of public trust water. The question is just whether that extends to this area. Michigan and Indiana reached the same conclusion that this should be open, right? To the strip of land should be open to the public, regardless of whether it's covered in water. And it makes sense, I think not only by today's standards, but even by those 1923 standards.
So take us back to that Winnebago case.
Yeah, so Dammel v. Jantz, 1923, Wisconsin Supreme Court holds that Jantz was in trespass under somewhat similar conditions as we have here, except it was on Lake Winnebago, an inland meandering water, which the Judge Kirchner seems to be thinking that Lake Michigan is. It is not considered an inland meandering navigable water in this context. And maybe the thought is like it's inland from the oceans or something, but that's not what is meant here, right? Even if this were the rule for Lake Winnebago and every other water, like within the state, which I don't know that it ought to be, but just assuming that it were, the Great Lakes are fundamentally different. And it's not out of the realm of possibility that we have a different rule for the Great Lakes. Unfortunately, as well thought out as this decision is, I think that's a very subtle nuance that the judge didn't catch, but is very, very important. What that means is that the Dammel case may not be exactly on point, could be distinguishable, right? Because we're talking about the Great Lakes and not an inland water, and could provide the ability for a lower court judge to not disregard Dammel, but just say, well, no, this case is different and that exact rule doesn't apply here for these reasons, right? For whatever they may be. And that will be up to, any judges who read the case and the attorneys who end up arguing it, right? Mr. Florsheim's been going pro se so far, so we'll see if that continues.
So why do you think it's taken so long for Wisconsin to be potentially on the cusp of sorting out this public trust issue?
I think that the public needs to stay vigilant, and folks like me need to stay vigilant in educating them about the full scope of their public trust rights. Not a lot of people really maybe understand that in the way Paul Florsheim does, and when confronted by a landowner may just relent. If you read the factual findings here, it seems that Mr. Florsheim had walked along that beach area several times before the village finally issued a ticket. But it was only because he had an understanding of his public trust rights that was different than the landowners, right? But he had an understanding, right? And was willing to be ticketed to stand up for what he believes is the proper interpretation. Sometimes it takes a perfect case like this on these findings of fact, or somebody willing to stand up and say no. If in fact Mr. Florsheim is right and there is a public right to access that portion, all of these trespass signs, ordinances, and all of those things themselves are unconstitutional, and have been chilling the public's right to access these places forever.
Any final thoughts at this moment in time?
This is an important point. There was a quotation in the findings of fact from the landowner here talking about it being his backyard where Mr. Florsheim was. That is not their backyard. Any land below the ordinary high water mark is owned and held in trust by the state of Wisconsin. Yes, they may have, all this case says, or all the law says right now, is that a riparian has exclusive right to access the exposed shore to exercise their riparian rights. But the land, even with that exclusive right to access it, is nevertheless owned by the state. Even if the public can't access it when it's exposed, does not mean it is the riparian landowner's backyard. I think that is important to mention. Even if the village of Shorewood is right, and the judge in their decision here holds true, it is not a free-for-all in that zone. There are still constitutional limits on how that land can be used. In this case, regardless of the outcome, shouldn't be an invitation to abuse that, because that's the real issue. And I don't think Mr. Florsheim, he's walking his dog down the beach in that area. And I don't really personally see that as an abuse. We'll see what the courts say. But there are people who do abuse that. Right? They're like public rights and landowners, both ways. And it's the lack of clarity. Okay, the law depends based on where the water is. That's not tenable. And it's the lack of clarity that results in these disputes and people abusing the rights that they do have and trying to limit those of others. And that's a problem. And maybe this case helps make that a little clearer.
Rob Lee is a staff attorney at Midwest Environmental Advocates, based in Madison. He spoke with WUWM environmental reporter Susan Bence. Head to WUWM.com to follow developments with this story.
Lake Effect is a daily talk show on WUWM, Milwaukee's local NPR station. It's a show where we share the stories about the people, places, and organizations that shape the city. If you enjoyed this episode of Lake Effect Spotlight, subscribe to the podcast. You can find all of Lake Effect's conversations at WUWM.com/Lake Effect, and we're on the radio Monday through Friday at noon on 89.7.
This is Tanya Mosley, co-host of Fresh Air. You'll see your favorite actors, directors, and comedians on late-night TV shows or YouTube. But what you get with Fresh Air is a deep dive. Spend some quality time with people like Billie Eilish, Questlove, Ariana Grande, Stephen Colbert, and so many more. We ask questions you won't hear asked anywhere else. Listen to the Fresh Air podcast from NPR and WHYY.